Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
People versus Cragg.
Ready at the court, please.
Mr. Bradley?
May it please the court, this is a DWI case dating from 1982.
Oh, we're familiar with the facts of the case, Mr. Bradley. Are you saying now, as opposed to what you might have said at another time, that this was not coercion?
No, Your Honor, I'm not saying it's not coercion. I'm saying that the main point is compliance or non-compliance with Section 1194 of the Vehicle and Traffic Law.
Are you contending that it was coercion, or are you not making that contention at this time?
Well, I don't want to use the word coercion, Your Honor. We're contending that Mr. Cragg changed his refusal to the test because of what the officer told him, in particular that if you refuse, you have to be taken in front of the magistrate, and bail will be set, and you'll end up in jail, whereas if you agree, we'll give you an appearance ticket and you won't have to be taken in front of the magistrate.
You don't want to use the word coercion.
Yeah. All right.
If you don't want to use that word, what word would you use as a legal synonym for what you have just described?
It's an aspect of coercion. It's just, I don't think that...
Oh, it just sounds like coercion.
Well,
It sounds like coercion, but it's really not coercion.
I just don't think it... I don't want to focus on whether something is coercive or not. I think the focus ought to be on whether the statute was complied with or not. The statute particularly saying that if the warnings are given about suspension and revocation of the license, and if there's a refusal, the test shall not be given. And that's where I think the focus should be, rather than whether this, what was said was coercive or not coercive.
Are you saying then that your theory is that, analytically, that if the officer recites the statute and no more, then you test it by the compliance with the statute by that literal articulation, and that anything else gets you into some limbo land which might be a violation?
Yes, I think so. If what is done then is further elaboration to make sure that the motorist understands the consequences of a refusal with regard to suspension, revocation, whether or not he's found guilty of the charge, I don't have any problem with that. But when you start getting into saying, well, wait a minute now, we've got a policy here, and this is not the legislative policy, it's a policy apparently by Monroe County Sheriff at the time in question, that if you refuse, you don't get an appearance ticket, whereas if you agree, you do get an appearance ticket. When you go beyond the statutory warnings and get into some other reason why someone should take a test, and change, this is assuming there's already been a refusal. You know, it's not a case where we got somebody questioning and saying, well, gee, what do you think? Should I take it? Is it going to go against me? Am I that bad? You know, that's not the situation here. He's already refused, and then the additional penalty is told to him that if you refuse, you're going to go to jail, or you're at least to be taken in front of a magistrate, and bail could be set or is likely to be set, whereas if you agree, you get an appearance ticket and you go home.
If you were to be very persuasive and convince the court, and I don't know even where I come out, no less any other member, in ultimate result, what would be the rule of law you'd expect us to announce with respect to this case that would not only decide the case, but govern all the others in connection with this kind of situation?
That with regard to whether a person consents or refuses to a chemical test, that the police cannot go beyond the statutory warnings and the content of what they say.
And if they do, automatic...
That's a more expansive rule. The more limited rule would be you can't threaten someone with jail or make it your policy to... You can't tell him after his refusal to get him to change his mind that he doesn't get an appearance ticket if he refuses.
There's no evidence here that this was a policy.
Other than the Assistant District Attorney's statements at argument before the town court, where he says these are all true facts, indicates that it was a policy to me. I don't know if there's any other statements in the record saying it was a policy of the Monroe County office. All right. That, Your Honor, is simply the issue on the second point, is whether the statute was complied with or not. I really don't have anything else to add to that. The first point is a question of whether he was properly stopped on the night in question. It's a situation where the police officer says, I stopped him for making an unsafe turn, and then changed his phrasing on that to a failure to use a designated lane. When asked, what did he do that was unsafe, he said, well, he turned from the middle lane when the left lane was marked for turns. The point is that the left lane's got an arrow over it saying if you're in the left lane, you have to turn left. Well, he didn't violate that. He wasn't in the left lane. The middle lane doesn't have any direction. It can go straight, it can turn. There were no signs indicating what direction the driver was supposed to go in. We submit that a turn left from that lane onto a four-lane road, so it's not like he's cutting across the traffic that would be going left from the left lane. But that kind of turn is not in any way illegal and doesn't provide a basis for the stop. Since that's what the officer says he stopped him for, we submit that there wasn't sufficient cause for the stop, and there should be suppression. Thank you.
Thank you very much, Mr. Bradley. Ms. Clifford?
Good afternoon, Your Honors.
You certainly don't think this was coercion.
Certainly not, Your Honor. That is, ours is basically a bifurcated position. One, that it is not coercion, even if it is conceded that what the officer said is exactly what is contested in the defendant's moving papers. The defendant submitted an affidavit which basically said he was told if he did not take the test, he would be taken before a magistrate. Bail would be set, and he would have to post bail before he could leave. If he took the test, then the desk appearance ticket would be issued.
If you take a test, you can go on home with a ticket. If you don't take a test, you're going to be hailed into court and have to plead and go through all this operation.
All your rights will be stringently protected, Your Honor. That's right. You'll be taken before a magistrate, and that magistrate would set bail as opposed to the police officer essentially letting him go in his own recognizance. I would first address the...
The assumption is that he knew what bail was and that he had money in his pocket to make bail and things like that, or else that would have been... Then, if he didn't have that, what would you say?
Well, I don't know, Your Honor, if in that none of those assumptions are anywhere close to the record. There is, lower case law where even when the statement was made, we're not going to arraign you for 5 days because our magistrates are so backed up, that might not be coercion. So that there are a lot of ifs, and that is one of our contentions in our brief, that the record before this court is just inadequate to make any determination on the coercion issue.
But I take it that somebody who submitted to the test, that you responded to one of my colleagues' questions, or however miserably that person failed the test, still would be free to leave.
Well, that is also not clear from the record, but it is, from personal experience, there are those who do take the test and are taken before the magistrate, depending upon whether or not they're acting obstreperously or have some other history or have if there's some indication it might be a felony.
How about they will fall down drunk?
Fall down drunk might do it, and if there were no one that could come and take the person home so that they would be a danger to themselves or the community, that would definitely be a situation where even if they took the test, they would be taken before the magistrate. It's not a hard and fast rule, I don't believe, Your Honor, but it's another place in the record where there is just nothing for this court to make such a determination.
What other purpose than a coercive purpose would this statement have?
Educational, that if you were in that situation, and I had already advised you, Your Honor, if you do not take the test, your privilege to drive in this state will be taken away from you, and if you persist in refusing, such refusal can be used in a court of law against you. you then continue saying, no, I don't want to take it, I don't want to, then I continue to advise you of the consequences of your action, and that it seems to me that the legislature is speaking rather clearly by saying that if you refuse, the police officer must immediately make out a report. Now, we all
Hypothetical.
Yes, sure.
Assume that the record showed this. Police officer arrests the man and said, all right, now look, if you take a test, you're going to get appearance sick and go home. If you don't take the test, this is what we're going to do to you. Take you down to the police station, you're going to go before the magistrate, he's going to set bail. You can't make bail, you're going to sit in jail. Maybe a week, maybe 2 weeks, I don't know, until the thing can be resolved, then a trial date's going to be set. Then you have it, but all you have to do is take the test and you get a ticket and you go home.
Is that coercion? Is that the question? Is that coercion?
That's the question.
That is, if nothing else, perilously close to coercion, in my opinion. What
In
we're
other words,
looking
you
for is your
think
opinion.
in this context, it could be. Depends how far you go.
Right.
And you say this doesn't get that far.
Right. I
And
don't...
besides that, your opponent doesn't even argue it.
Right, which I'm real pleased about, yeah, you know. His reply brief was real nice for me, because I'd really like you to decide a real narrow issue, because I can't see in all good conscience where this court would ask our police to adhere so stringently to a statute and say, you can tell them this much, but if you tell them one word more, that's it. Test can get thrown out.
Should there be no sanction? This is, after all, the command of the legislature. Should there be no sanction if that's violated?
Well, let's talk about the command of the legislature. It is very unclear to me, Your Honor, that the legislature is commanding that. Later on in Section 1194, I believe it's subdivision 4, where it's talking about whether or not you refuse and whether or not this can be used against you in a court of law, the actual wording is that it contemplates refusals. A refusal may be admissible in court, but only if clear warnings have been given of the effect of such refusal and that the person persisted in such refusal. They're not contemplating one refusal. They're not contemplating a cut and dried, if you refuse, your license is going to be taken away and it may be used against you in court. And then you're supposed to lock the lips and throw away the key. Can't say anything more. To me, is clear that is not what the legislature intended, that the police can only say these few magic words and nothing more. That it is the obligation of the police to advise this individual who doesn't have a right, as this court said in People v. Thomas, to refuse to take the test, that the officer has an obligation to tell them all the consequences of their action. And if an individual, and in New York we have the implied consent statute, if they are revoking that consent and saying, all right, I want to use the highways of New York, but I don't want to play by your rules, I don't want to take the test that the legislature has said I must take, then it seems only natural and reasonable that the police should, and again in the statute they are required immediately to make a report. There seems a clear inference that that report, which must be made immediately, is not to be put on somebody's desk and to let this person drive away. That person should be brought before a magistrate if they don't wish to play by the rules of New York State's roads.
Take you to another subject. Is this a valid arrest?
Yes.
What did he violate?
Well, as this court has stated in People v. Engle, the police officer need only have an articulable reason.
Yeah, well, that,
Now, whether or not...
there was a dispute there about the facts, the factual predicate for the arrest. But what offense, what provision of the vehicle and traffic law did he violate here?
Failure to obey the road markings, 1128C, I believe, of the vehicle and traffic law, in that there was a clear lane designated for left-hand turns, that he was in the middle lane of the three-lane demarcation. Another vehicle, indeed he was stopped, another vehicle had to go around him. He then made a left-hand turn from the middle ongoing lane.
Have you got any authority that says that was an illegal turn?
Well, let's put it this way, Your Honor. Whether or not, if I were in the town courts here and trying to prove that case, it might be a tough case to prove beyond a reasonable doubt that he violated...
As a matter of fact, they apparently thought they couldn't prove it.
Well, whether or not, I don't think that's the issue, because whether or not it could be proved beyond a reasonable doubt is not whether or not that police officer thought on that evening that a violation had been
I'm just trying to
made.
find out what the violation was.
According to the police officer, it was indeed that he made a turn from the wrong lane, 1128C, failed to obey the traffic, the markings to make a left-hand turn. I see my time is up.
Thank you
We
very
would hope
much.
that you affirm.
People versus Berrios.
Ready to court, please.
Mr. Halloran, what was the nature of the objection made at the time they sought to introduce the evidence of this accident?
We submit, Your Honor, that the objection was strenuous and it went to the points of materiality, relevance, and the prejudice of the uncharged misconduct evidence.
Now, assuming that that was well preserved, explain to me why this case isn't completely controlled by Henson and the fact that this prior conduct would be very relevant when it comes to the particular crime charged.
In Henson, the defense of accident was affirmatively interposed by the defendants in that case. That is not the case here. In the case at bar, the prosecution utilized the pretext of the defense of accident to get this evidence in the back door, essentially. In Henson, there was an interposition of the defense. That is not here.
The
Henson is
general
distinguished.
ruling in Henson was to the effect that the prior parental violence, this pattern of conduct, could be shown in this fashion because these acts aren't often committed in public, that we want to know what the background was with respect to the relationship between parent and child. Why isn't that just as relevant here as there?
I do not dispute the exception to the Molyneux rule recognized in Molyneux itself and in Henson. The difference here is on the issue of relevance, the defendant had never admitted to participation in the acts. In Henson, the defendants did admit to the participation in the charged acts.
The same thing is true, however, in Alvino. There was a denial.
In Alvino, Your Honor, there was a bona fide question of the scienter. That was in the case at issue.
But in Alvino, the counsel disclaimed any issue of intent, any issue of mistake, and at first, it was outright denial. Now, here, apparently, it's alternative. Didn't do it, but if it did happen, it was an accident. Doesn't that bring you within Henson?
Your Honor, the problem with analyzing the relevance here is we do not know the true nature of the accident defense. Defendant never formally interposed it at any stage of the proceedings. We don't know the purpose for which the defense was raised. The defense can be used in two contexts, either where you admit participation in the act and therefore the evidence is admitted by the prosecution to demonstrate mens rea, or secondly, in the outmoded context to show actus reus, or the human intervention element necessary to prove the crime. Here we can't adjudge the relevance because we don't know the issue to which the evidence was admitted. And I think that the full court in Alvino has recognized that uncharged misconduct evidence is properly admitted only where the acts for which the defendant has been charged are equivocal in nature. Here we have a case of child abuse where the crime charged was clearly unequivocal. The placing of a child's hands on flames is the type of act from which the intent can readily be inferred. Evidence of uncharged misconduct was not necessary to demonstrate the intent here, as perhaps it was in Alvino. The question of materiality, I believe, Judge Wackler, is fully preserved because of the reference in the record at page 35 to People v. Santoro, the theory that the prosecution went by was clearly the defense, and there was a reference by the defense counsel that the evidence was outside the parameters of the indictment. I think that can be fairly inferred to raise the issue of materiality. Second, even if it were not properly preserved, I would ask that this court apply People v. Ahmed or People v. Patterson to recognize that this is the type of issue which affects the mode of proceedings prescribed by law and is properly addressed and resolved by this court.
Mr. Halloran, there's overwhelming other evidence of guilt, isn't there?
Your Honor, the harmless error analysis is inappropriate here. Under People v. DeJarmo, this court recognized in 1904 that the admission, the wrongful admission of this evidence raises a conclusive presumption of prejudice to the defendant. And in People v. Allweiss, this court recognized that that was true in the modern era as well.
You say there can be no harmless error analysis here?
Not in this case, Your Honor.
Mr. Halloran, what would the implications of applying the Patterson fundamental error rule to a Molyneux evidentiary situation be, do you think?
Judge Bellicosa, I think that when we're dealing with the issue of materiality, we're dealing with the order in which the evidence is admitted, the context in which the evidence is admitted. In that instance, we're dealing with a question of court administration, if you will, which is prescribed by law. The order of the proceedings is very important, and because under Patterson, or perhaps more properly under People v. Ahmed, I think that this error does clearly affect the mode of the proceedings, and this court can still address it.
If you're right, the practical consequence would be pretty much the elimination of any preservation requirements in this category of evidentiary presentation, would it not?
No, Your Honor, I don't believe so. I think that the utilization of that exception is within this court's discretionary power to invoke. I don't think that it's mandatory that this court consider the question, but I would ask that you would.
Could we consider the overwhelming evidence, if not otherwise, available to us in connection with the exercise of that discretion then?
That's a fact-finding function, Your Honor, which I don't
You
think...
may not be able to have it both ways. If you want us to invoke discretion, you can't then turn around and say, well, you can't do any fact-finding
No,
either.
I would ask that you exercise the discretion on the particular issue of the preservation, which is, I think, within this court's power. The evidence was clearly immaterial. The evidence was clearly irrelevant. There was no need to introduce this evidence for the very clear purpose that the prosecution intended to admit it. They tried to admit it on the defense of accident. The defense of accident was not in the case. A fortiori, if the defense is not in the case, it cannot be a relevant issue. Moreover, on the issue of relevance...
By the way, that argument was not raised below,
Which argument, Your Honor?
about the defensive accident not being in the case. I think the only argument made was prejudice for the objection.
Your Honor, are you asking me whether the issue was raised at the appellate division or at trial?
Trial.
I submit that it was.
Accident?
The issue...
The argument that you're now making with respect to the accident defense?
The action of the materiality issue, yes. I believe that was raised at the Molyneux Ventimiglia hearing. I would construe the language of defense counsel pointing to the fact that this evidence was outside the...
Would it delay you more than 30 seconds to give me a page reference?
34, A34.
Thank you.
Was Molyneux mentioned in the objection? Or any of the Molyneux cases?
Yes, Your Honor, there was. People v. Santoro, a second department case, which was clearly on the issue of the defense of accident. The case was cited by the prosecution in response to a request by the trial court to justify their efforts to enter the evidence. In Crandall, this court recognized that where the theory of the defendant is one of total non-involvement in the crime, it is improper to impute to the defendant any theory of mistake or accident. In this case, we have a plea of not guilty, and I would suggest to this court that because of this plea of not guilty, defendant has also recognized that and asked the trial court and the members of the jury there that they recognize that he was completely uninvolved with the crime. Where there's a suggestion or a claim by the defendant that he's completely uninvolved with the crime for which he's charged, it's improper to impute any suggestion of accident or mistake. It's facially and logically inconsistent with the defendant's theory of the litigation.
You think that statement that you just made is completely consistent with the court's holding in Albino? The statement that you just made.
Your Honor, I think Albino is clearly distinguishable here, and I think that there is language in that case which could be viewed as...
As being inconsistent with what you just said.
Yes, Your Honor. Yes, Your Honor. The final tier of the analysis is that the evidence, if material and if relevant, it has to be shown to be of greater probative value than the prejudice for which could result upon its admission. In this case, we have a situation where the prejudice was clear. Defendant was not linked to the rib injuries charged in the indictment except by this evidence of the prior uncharged misconduct. The evidence was clearly prejudicial. It was of scant probative worth. Thank you very much, Your Honor.
Thank you very much, Mr. Halloran. Mr. Gregorio?
Good afternoon. Your Honors, initially the people would submit that the contentions that appellant currently raises are in fact unpreserved for this court's review. At trial, defense counsel objected to the introduction to this evidence on the very broad basis of prejudice, and he also stated to the effect that it's not a crime within the indictment, and that was it. At no point did the defendant object to the fact on the grounds that it was immaterial, irrelevant, and defense counsel certainly at no time ever raised the issue of accident as a non-issue, although the people would point out that he was provided with ample opportunity, since the people did in fact state, Your Honors, we intend to introduce this evidence to negate the theory of accident.
Counsel says, however, that there was a Molyneux-based objection somewhere, I think on page 34 or somewhere around there.
Yes, Your Honor. Our counsel referred to the case of Santuri. This was raised by the prosecutor. The prosecutor briefly interjected it, but at no point in time did the defense counsel make clear that in fact he was going to adopt this, or in fact that was the basis for his objection to Mr. Glarz' testimony.
But was the issue brought to the court's attention, albeit by the prosecutor?
Your Honor, the people would submit that in fact it was not, that the court merely overruled counsel's objection on an evidentiary matter based upon Henson, for example.
Was Henson ever mentioned at all at that time?
No, it was not, Your Honor.
And is Henson sufficiently distinct based on the assertions that your adversary made that we could view this as a reconsideration, in effect, of Henson? I mean, do you see it as us looking at it afresh or applying Henson? Which would it be in your interpretation of the argument that's been advanced to us?
Your Honor, the people would submit that Henson still remains viable law and is entirely consistent with the decision rendered in this case. That is, we have a very serious child abuse case where the defendant asserted to various authorities, this all happened by accident. My child was very clumsy. This is almost exactly what the defendant in Henson told authorities and medical personnel, that in fact the grievous injuries that caused the child's death were due to the child's clumsiness or perhaps to accidents. So in other words, Your Honors, the people would submit that this case merely reaffirms the propriety of this court's decision in Henson.
So you don't credit the distinction that was advanced with respect to the admission as to the conduct in Henson and the non-admission, so to speak, in this case?
Well, Your Honors, the people would submit that in regard to admission, Henson and this case are similar. There really is no difference between Henson and this case. You have the defendants in both cases out-of-court assertion to the police and medical authority that these atrocious conditions on the child were indeed caused by accident. I think the two cases are very similar. And quite frankly, it's my reading of Henson, I do not find where the defendant affirmatively asserted accident in a formal pleading. I just do not read the case in
Your
that
point
manner.
being, if I may characterize it then, whatever distinctions are there of no legal consequence.
That is correct, Your Honor. Your Honor, even if this court could somehow deem this issue sufficiently preserved, which again the people most strenuously urged, it has not been. Clearly, the probative value has outweighed the prejudicial value. That is a line of cases, including Henson, really make note how appropriate it is in cases involving child abuse, which do in fact occur behind closed doors, to offer this sort of evidence to negate the fact, the parents' claims that the child's condition was caused by accidental means. And indeed, Your Honors, that any prejudice was clearly de minimis. Here, the jury was exposed to various crimes, horrendous injuries rather. The testimony introduced was truly of a rather innocuous nature, although once again highly probative on the issue of non-accident. Your Honors, if there are no questions, the people would ask that the judgment be affirmed. Thank you.
Thank you very much, Mr. Berrios. Matter of State Division of Human Rights versus Cook.
Good afternoon, I'm Edwin Wolf. In 1979, Mr. Pecci returned to his job with S.A. Cook as a factory warehouse manager. He was offered an alternate position because of his history.
He had a bypass, a coronary bypass.
Yes, he had a coronary bypass
And the boss
operation.
determined that he couldn't do the work as a warehouseman, having had the bypass.
I don't think that's a conclusion that should be drawn, and I don't think it's even a conclusion that fits with the law or the test that's applicable at the time. The question isn't whether he could or couldn't do his job as warehouse manager. And therein, I think, lies part of the difficulty that has divided those who have heard this case before. The case is whether or not his illness is related to his job. That was the law in Westinghouse and I believe Averill Park, and that is a test that is to be applied in this case. And if one examines the record, as I know the court has done, I conclude, as I would hope that since others have been split on this, that at least 4 of the justices here would join in this opinion of mine. You would find that
By the way, you know, even though the court might split in a prior determination, we come together because of the precedents established by that prior determination.
well,
Stare decisis. We don't remain forever divided.
the divisions well, it's very interesting. There are 2 divisions in this case. One is the division of human rights, and then there's the division within itself. Very interesting course that this matter has come from Medina to Albany in 9 long years. And that is if we examine this, that the division, someone in the division didn't even believe that there was probable cause and said that after Westinghouse and Averill Park, maybe we ought to take another good look at this case. And it's it's in the record, it's an early part of the record, and the page is the record. And that's a very detailed explanation in which he has written out the cases and the holdings of the Court of Appeal on the subject of the relationship of the job and the relationship of the disability of the job. And then we have this marvelous decision or determination after a hearing or whatever it's called in there, in which somebody in the division says, after investigation, I say there was probable cause, kind of a royal proclamation. There is probable cause because I have pronounced it so. Then it goes to the hearing officer. Hearing officer finds no probable cause. He has a long series of recommended findings of facts and conclusions of law. And the commissioner takes them almost verbatim. It strikes paragraph 18. Interestingly enough, in striking paragraph 18, they don't even bother to change the numbers. I mean, there's not even any subtlety in that. And they take, they kind of like white out the not from did not discriminate, and then let's go on. And I think it's all, I think you can see the split at the appellate division. The affirmation at the appellate division is brief and says there's substantial evidence, and in the dissent.
Can afford to be brief and find
Yes,
substantial
yeah.
evidence.
Yeah,
That's the case.
it's a wonderful test, and I remember learning it in administrative law.
Sometimes it's going to be even briefer and say affirmed.
Yeah, then if that had been all that was in here, then I wouldn't be here today. I guess one must be thankful for the two dissents at the appellate division. And
If you like trips to Albany.
well, I always like coming to the Court of Appeals. It's always been a very pleasant experience for me. I certainly would. I'm hoping it will continue to be thought of that way when I leave. But of course, I know there are no guarantees. Yes, sir.
Let's just assume that substantial evidence is the test.
I'm sure it is.
I must be frank and say that I agree with you. I think it is. But let's assume further, and I think I'm right on this, that it's the pre-1979 statute which applies.
Yes, I think that's clear.
And assume further that under that statute, job relatedness is the test. Why is there not substantial evidence, as the appellate division majority found, that there was job relatedness between this man's heart condition and the work that he was supposed to perform?
My answer to that is because I don't think there's any evidence that,
Man,
I don't think there's any evidence in the
man has
record.
a heart infarction or whatever it was, and does he have to do lifting?
He did. There is clear evidence in the record that he was involved in some manual labor, that he had to lift up the furniture, and that from time to time that he had to do it. Substantial evidence is the test. The question is substantial evidence of what? And I say that the test that's to be applied in this case is there substantial evidence in the record that his disability was job unrelated, or is there substantial evidence in the record that his disability was job related? I say the only evidence in the record is that his disability and his job were related. There is no evidence in the record that his disability and his job were not related. The medical evidence is that they were related.
We have a medical evidence to the effect that this person, after this operation, could return to his normal duties. Against that, we have the judgment made by a lay person, his employer, that he could not. Why couldn't the commissioner, based on this, find that there was substantial evidence to support the petition?
I don't think that I'm sorry, I didn't mean to interrupt. I don't believe that the evidence that of the Dr. Fernandez is that he could return to work. First place, there was an allegation that Mr. Petchy had a note when he returned to work, and the note was never produced, and Mr. Carmel said he never saw it. There's nothing in the record which shows that Dr. Fernandez knew what Mr. Petchy's job was, that he was examined or tested to find out whether or not he had recovered in a way in which his job, which involved his job. Basically, the only evidence in this record is that Mr. Pecci had bypass surgery, that the operation was successful, and that he had a post-operative period, his recovery period was successful, and that his symptoms that arose before the time did not show up later on. In fact, it's quite suggested by Dr. Rosing that one doesn't know what tests were run on Mr. Pecci to determine his ability to do virtually anything, including his job, and that certain tests would be better advised. There is some reference to a stress test, and there's also some reference in there to the fact that it was stopped at a certain time, and Dr. Rosing says he wonders why it was stopped. It should have gone on. I don't think there's any evidence in the record that his disability and his job were not related. I think quite to the contrary, the only evidence in the record is that his disability and his job are related. And it's kind of like getting. I remember when I went to school, you get a note from your mother that says, Eddie can go back to school now. It doesn't say anything. It doesn't tell me on what basis is his judgment made. What did Dr. Fernandez do? Dr. Fernandez said he had a heart. It basically says he's okay, can go back to work. Doesn't say he knew what his job was, what it entailed, or anything else. There just is no evidence that there's any consideration by Dr. Fernandez of what Mr. Pecci's job entailed and what it involved. And that's the shortcoming of the substantial evidence test that supports the commissioner. There is no evidence at all. And I think that runs throughout the entire record. And the case is, someone is trying to make this case and make this decision on the lack of a medical exam by S.A. Cook. Dare say that he had a medical exam by S.A. Cook. The only thing I'm positive about is that you wouldn't be listening to me today. That I wouldn't be here. He didn't have a medical exam. There's nothing that mandates that he had to have a medical exam. McLean Trucking doesn't do that. There were some federal regulations. Arno Ogden doesn't dictate that result, and neither does Donnarumma. And none of these cases dictate that he had to have a medical exam. I think this case is just remarkably similar to the case of the hearing-impaired bus driver. And that is that there was a relationship between the hearing impairment and his driving a school bus. And the test in that case, it seems, in my recollection, is exactly the same. The question wasn't whether he could drive the school bus or he couldn't drive the school bus. In fact, my partner who accompanied me today said she thought that perhaps a hearing-impaired school bus driver might have a decided advantage rather than a disadvantage. But that was, the court held that was a disability related to the job. And I think that's exactly what the evidence in this case is. His disability was related to his job. His disability was related to manual labor.
Thank you very much.
I see the red light. Thank you.
Ms. Downey?
Good afternoon, Your Honors. This is a case about two furniture company employees who made a medical decision. They themselves had no medical training, conceitedly, about another furniture company employee who had had a successful coronary bypass. The general manager and the president of this furniture company decided, without talking to the complainant or his doctor about the condition, without consulting any medical professional people on their own, and without sending complainant to a doctor to be examined themselves, just decided that the job of warehouse manager was too strenuous to him. Complainant was only 37 years old at the time, had not had a heart attack, had had atherosclerosis and some angina for which he had had coronary bypass surgery. And he did have a note from his doctor, the commissioner found, that stated that he was able to return to his usual duties at work. And the suggestion of the doctor, who had been his cardiologist, would not know what his duties were in a heart patient with malpractice looming over doctors' heads, I think is not a real logical one. I can think the commissioner could assume the doctor wouldn't send him back without knowing what he was doing and that he could do it. And all that the commissioner ordered in this case is that S.A. Cook have Mr. Pecci examined by a heart specialist. We know the relatedness test is a very narrow one, as developed in the pre-79 amendment. Commissioner didn't find job relatedness. He just said it was discriminatory for two lay people to make a decision about this man's physical condition, which may in fact no longer exist in a disabling situation. And the dissent and the appellant here, the dissent of the Fourth Department and the appellant here, suggest, well, no, a common sense standard should apply. But I would submit that a common sense standard can apply with respect to heart ailments, corrective measures taken with respect to heart ailments. And the S.A. Cook's expert really established this as well, because the expert, which was brought in just for purposes of litigation, there was no kind of medical advice prior to the termination decision. But the expert stated, really, in 3 separate letters, I think that the appellant was trying to get more out of them than they were able to get, in 3 separate letters, that really what he needed was more information, that Mr. Pecci should have a stress test, that Mr. Pecci should be examined by a cardiologist, and then they could determine whether he was able to do the work or not, or whether it was related in terms of the pre-79 standard. And S.A. Cook admitted this in page 10 of its brief. It says, Dr. Rosing stated without testing or some objective evidence, he cannot determine whether or not Mr. Pecci's disease is related to his job. This is all the commissioner has ordered here with respect to reinstatement. The idea that common sense would dictate that if someone has some kind of artery disease, which is corrected, the person is forever unemployable under the pre-79 standard is really very harsh. And again, Cook's own expert says, and I think this is very important because it goes to the idea of whether there can be common sense applied. And this man, after looking at all Mr. Pecci's records, was able to say that if an individual has not had significant irreversible damage to his myocardium, his heart muscle, his heart will be able to function in a normal or nearly normal manner after successful coronary artery bypass surgery, and such an individual should be without physical restrictions. And, you know, the standard is a disability unrelated to work, but if the person is essentially without physical restrictions,
What you just read is in the record?
Yes, sir, that's page 531 of the record on appeal. And again, what the appellant's expert urged is what the commissioner has ordered. And the other cases which this court decided of Averill Park and Gee and Westinghouse and Feinberg are clearly distinguishable for this, because each and every one of them had an employer's doctor saying this person has a disability which is related to his ability to do the job. And in this case, we have no such person saying any such thing, nor is the conclusion even after the fact by an expert at all conclusory about that. In fact, he says, I need more information. Examine him further, and he may well be employable. He says this. And I don't think we can compare a permanent disability situation which may through treatment become unrelated to a job. And the Third Department in the Arno Ogden case stated that very eloquently with respect to heart ailments, although that was a hypertension case, spoke of heart ailments as being a situation in which can become unrelated through treatment. None of those other cases which involve dermatitis or hearing loss or a lame leg, there was no suggestion that the disability would not continue to be just as disabling, if not more so. So with respect to the substantial evidence standard, not with the standard, but the substantial evidence before this court, I think however narrowly the pre-79 statute may have been construed, and of course the legislature changed that, and we hope this is the last case you all will see with respect to the pre-79 statute. I think it's certainly not so limited as to include those cases that where lay people can make these kind of really basically uninformed and mistaken, in this case, determinations without any basis in fact, and especially with a complex medical matter. There could conceivably be matters that a person could use common sense. This is, and so I'm not saying that there has to be a standard where there has to be a medical examination in every single case. It's not a requirement, but common sense requires that lay people don't know enough about heart disease to make a determination about whether this man was disabled with a medical condition that was related to his job or not, which is what the commissioner has asked here.
Thank you very much, Ms. Downey. Matter of FW Woolworth versus State Tax Commission.
Ready.
Mr. Bray, why was the Tax Commission's use of the federal regulatory guidelines and the decision under the federal courts under 26 U.S.C. 265-2 so off kilter in using this in this reasonably foreseeable test? Doesn't that seem a reasonable application of this law?
These investments were made 20 or 30 years ago. I don't think it was reasonably foreseeable at that time that there were going to be working capital needs of the magnitude that developed. I think the purpose of connection doctrine, which is adopted by the cases, refers to the circumstances at the time of the debt, not the time when the investment is incurred. I think what happens is if you have an investment in tax-exempt securities under the federal regulations that's close enough in time, they will impute the prohibited purpose to a later debt on the theory that when you're borrowing the money, you must know at that time that you're replacing working capital or funds that you should have kept and not invested in tax-exempt securities. I think the timing feature is very important in this case. The investments here were old and cold, and from a cost standpoint, the actual cash investment that was made, they were inconsequential. What you have here is a case where the investments have just grown to large proportions, and the mere creation of this value is being given as a reason to be as a connection between the debt that's later being incurred. The record is quite clear that the debt was not incurred to make advances to subsidiaries. Hence, there was no chance of a double tax benefit being exploited here. None of the abusive intent that the statute, the New York State or the federal statute, was intended to avoid present.
Is there no circumstance when the continued growth, accumulation of tax-free earnings in the subsidiary, growing, a great pot of gold out there, when it can be said that the parent
Yes, there would be a circumstance.
should tap some of that and avoid borrowing? Is there any circumstance?
Yes.
When does that occur?
When you have a unitary operation. This company is unique in that its subsidiaries operate separately. I think when you have subsidiaries that are so much a part of the parent company, you can practically ignore the corporate veil for purposes of a statute like this.
But aside from that, as long as there's no temporal connection between the investment, as I gather there was not here, because it was many years ago, and you've got this growing wonderful pot of wealth out there, you can just keep accumulating, and the parent can keep borrowing for its own needs.
In our case, I can conceive of situations where it would be proper, but where you have a merchandising business, subsidiaries are conducting merchandising businesses just like the parent is, and they have the same business cycle. They have need for cash just when the parent does. You can't just assume that cash is available. Moreover, why make an allocation for dividends that aren't declared, for earnings that aren't declared? The idea was to penalize a taxpayer who's making investments to create tax-free dividends. The state's methods seems to me to be do just the opposite of what the statute was intended to accomplish. There could be situations, I suppose, where you had a subsidiary that was, for example, if the subsidiary was a holding company for liquid type investments, or it wasn't an operating business, if it was making investments in securities or what have you. But I think an operating company, I don't think you can assume that that money is available. Furthermore, if it comes up to the parent, it might be used to pay dividends to the shareholders of the parent company, rather than, there's no assurance that there's no necessary relationship between the debt incurred in the business of the parent and the earnings that are available in the subsidiary. It's a non sequitur in this case. I think what this case is all about, the essence is, are we going to, or are the courts, is this court going to permit the statute to be interpreted in such a way that it virtually has no meaning? If you're going to, if the State Tax Commission is going to be permitted to make allocations just by virtue of there being value in the subsidiary capital, then the legislature might just as well have provided for absolute authority to allocate at any time. This is not a substantial evidence case. There's substantial evidence to support the state's position. It's erroneous position. There's substantial evidence to support an erroneous view of the law. I think what we have to ask ourselves here, when we're looking for the connection between the debt that is incurred and the investments, the subsidiary capital, we can't just look for any indirect connection. Even if you can say to yourself there's cash available to pay down the debt, is that relevant? I think what we have to do is look at the purpose behind the statute. The policy behind the statute was to prevent a taxpayer from benefiting twice, once from the deduction for the interest paid on the debt, and secondly from the dividends that would be received. Here, we don't have that. The record is quite clear that the borrowing was made for business purposes. It's very much like a borrowing that's made to purchase real estate secured by a mortgage, which is frequently cited as an example in the federal cases, to carve out from the allocation to the liquid type of assets that you have in the federal situation. I see my time is up, so I will stop. Thank you.
Thank you. It's not quite up. If you, well, let's say that you can save 2 minutes for rebuttal if you feel compelled.
Thank you.
Mr. Dow.
I please the court. Mr. Bray alluded to the fact that these debts were relatively recent in nature. I think the record doesn't support, in fact, the record doesn't support how long Woolworth has been carrying debts to furnish, to obtain working capital. The burden, of course, was upon the taxpayer to show that this interest expense that we're talking about was not indirectly connected with the subsidiary capital.
Well, isn't it directly attributable to the merchandising operation?
Yes, it is, but at the same time, it had a dual purpose. It also permitted the Woolworths here to carry these subsidiary corporations from which it obtained dividends, and these subsidiary corporations retained some of their earnings, but the dividends that they did transmit to Woolworth is not subject to New York tax, because subsidiary income from subsidiaries is not subject to tax. So what they're doing is they're carrying a debt which allows them to carry these subsidiaries, earning income on it, in effect having exempt securities, taking an expense for the carrying of those exempt securities and getting a double tax benefit as a result. They're taking a deduction for expenses for an investment in which we can't subject to income tax.
Saying that borrowing by the parent for current operating expenses and deducting that interest when the parent owns a subsidiary which has available funds which they could tap, thereby making it unnecessary to borrow, is enough?
Under the federal guidelines, that is enough. To carry,
Where is any substantial evidence? What's the test? What's the guideline?
the guideline says,
Well, and it would strike me that you can do it any time if you wish, and you can not do it if you wish. Why isn't it completely arbitrary? I believe it's argued.
the test is if you're borrowing money for working capital, and it's agreed here that the monies borrowed was for working capital. There's nothing, and at the same time, if you are carrying tax-exempt securities, which is not subject to tax, there's an inference, there's an indirect relationship.
But what's to say that the tax commission should disallow interest in one circumstance and allow interest deduction in another?
The test is,
I mean, I'm assuming that's not traceable at all as far as the initial investment in the subsidiary is concerned. Let's assume the case, the investment's made a long time ago and you've got a continuing, growing accumulation of funds.